this is probably the most important environmental case that the Supreme Court has on its docket this term so far. Anyway, there are some others the court might grant review involving the Clean Water Act, but right now, the Weyerhaeuser case under the Endangered Species Act is sort of the biggest environmental case. It involves a question of when the U.S. Fish and Wildlife Service can designate critical habitat for a species, in this case, the dusky gopher frog, where the habitat in question is not currently occupied by the species. It's historic habitat of this frog. This is one of the most endangered frogs in the world. Its population currently is estimated at just a little over 100. It exists solely on 2 ponds in Mississippi. And the scientists said if you're going to save this frog and recover it, you're going to need to expand its population and reintroduce it into other areas of its historic range where it doesn't currently exist. One of those areas is in Louisiana, in St. Tammany Parish, Louisiana, and this property happens to be owned by the Weyerhaeuser Timber Company and one other company. And of course, they have other plans for the property than using it to preserve habitat for the frog. And so Weyerhaeuser has challenged the authority of the Fish and Wildlife Service to designate its property as critical habitat. The key here is this frog requires very specific kinds of habitat. The most important ingredient is what are called ephemeral ponds. Ephemeral meaning they're only wet during certain seasons of the year, and they're isolated from any other water body. That's critical because the frogs, of course, lay eggs, and they must lay them in a pond where there are no fish, otherwise they'd be eaten. So these are very, very unique ponds. The frog, like many of the species on the endangered species list, has suffered catastrophic loss of its habitat, over 95%. It used to be found throughout the southeast in the longleaf pine forest ecosystem, and that ecosystem has pretty much been destroyed by conversion to other kinds of forestry, agriculture, urban development, and so forth. So the scientists said these ponds on the Weyerhaeuser property are actually the last of their kind throughout the entire historic range of the species. So Fish and Wildlife Service said, in light of this science, we designate these ponds as critical. But here's the problem. The frog actually spends 80% of its life underground. So these ponds are for breeding, but the rest of the time the frog is literally underground. And it used to be in this old forest that there were burrows. Interestingly enough, the burrows were dug by a species of tortoise called the gopher tortoise. You get the idea? And so that species is also endangered. And the consequence of all this is the habitat associated with these ponds on the Weyerhaeuser property has been degraded to the point where it doesn't really provide that kind of underground habitat the frog needs. This is a long-winded story, but it shows you how complicated some of these questions that come to the court can be. They look relatively simple on the surface, but they're anything but simple. So the lower court found that the designation of this critical habitat was lawful, and it upheld the Fish and Wildlife Service. Weyerhaeuser took the case to the Supreme Court. The Supreme Court, much to my surprise, and the surprise I think of a lot of people, granted review. The Supreme Court only hears 1% of the cases they're asked to review, so they have very limited time to spend on cases, and they're usually big cases, constitutional law cases. So it was a surprise that the court took this particular case, since it only involves about a 1,600-acre parcel of land in Louisiana. But because there are these property rights aspects to the case, and that's, of course, one of the things that Weyerhaeuser is arguing, is that this is our property. Government shouldn't be able to tell us what to do with it, and you shouldn't be able to designate it as a reserve, as they would put it, for endangered species. And so maybe that's why the court took it. So what happened was the Supreme Court has now reversed the lower court, the Fifth Circuit Court of Appeals, which sits in New Orleans. It did so on a very narrow ground, very technical. It basically said, because this associated upland habitat has been degraded, you couldn't actually reintroduce the frog into these ponds right now because they probably wouldn't survive. And so the Supreme Court was troubled by the fact that the lower court didn't dig more deeply into what it would take to actually restore the upland portion of the habitat so that the frog could actually exist there if it was going to be reintroduced. And so on that really narrow question, the Supreme Court has sent the case back to the Fifth Circuit, where there will be another round of hearings and briefs and arguments, and we'll have to wait and see how the Fifth Circuit rules on that. There's one other issue the Supreme Court ruled on and sent back to the Fifth Circuit, and that is the question, did the Fish and Wildlife Service adequately consider the economic effects, the economic consequences of designating this property as critical habitat? That's a requirement under the Endangered Species Act. When you designate critical habitat, the agency must conduct an environmental analysis. It doesn't require a strict cost-benefit analysis. It doesn't require that the agency demonstrate that the benefits of designating the habitat outweigh whatever costs there might be to restricting development. But it does require a thorough examination of the economic effects before a final decision is made. The lower court said that kind of analysis, economic analysis, isn't even reviewable by the court. It's basically committed to the agency's discretion. The Supreme Court said, no, that's not right. It is something that can be subject to review to make sure that the agency properly carried out the economic analysis. So that's the second question that the Fifth Circuit is now going to have to review and decide. Did the Fish and Wildlife Service do an adequate job of analyzing the economic effects? I should say that our environmental law clinic filed an amicus brief, friend of the court brief, on behalf of a whole group of environmental law professors who specialize in endangered species law. And so therefore, we were disappointed in the result. It's technically a loss, you would say. It's a temporary, at least, setback for trying to protect not only this habitat, but of course the question goes much more broadly than that. Because if, for example, the Fifth Circuit or the Supreme Court ultimately rules that habitat must be immediately capable of supporting a species before it can be designated critical, that's going to severely limit the options for recovering species. Most of the species on the list are there because of habitat loss. More species are being added all the time because of climate change consequences, which are affecting everything from migration to the survival of species at higher elevations and at certain areas of the country where the species are being pushed out of their historic range, pushed towards the poles. All of this scientific analysis of what climate change is causing is creating great risk to a number of species. And so that's why being able to designate habitat that's currently not occupied is going to be even more important as species are forced to move in response to climate change. It's also important for lots of species whose historic habitat has been degraded, but it could be restored. And in fact, it will have to be restored if the species are going to be saved and recovered. That's what makes this case more important than just the fate of this one frog, although that's important too. But the bigger question is, can the Endangered Species Act be used to protect habitat that's not currently occupied by the species, but is vital to the survival and recovery of the species? So that's where we are with the case. It's going to take another year or two, I think, before we get any final answer to this question. Litigation takes a long time. And so we'll all have to wait and see. Our clinic will probably be asked once again to weigh in on the case in the Fifth Circuit, and that will probably come sometime next year.